Today's topic will be defense of consent. We will discuss defense of consent, offenses against the person, actual bodily harm, and grievous bodily harm. As an example essay question that we will talk about today is defense of consent should not apply to ABH and GBH, critically analyze. Firstly, let's talk about the plan, how you should answer this kind of question. I've seen similar questions to this a lot of times as coursework, as well as on the exam of criminal law. So I suggest that you revise this topic and you understand the structure of how you should draft an answer to an essay question like this. What are the relevant case law? What are the relevant arguments? And this plan that I propose should be followed. In the introduction should be about 10% of the entire essay. So for example, if you have a coursework of 2,000 words, the introduction should be 200 words. So 10% of the entire length of the assignment. In the introduction, you should not give any arguments. You should only define and set the scene for the discussion. So in this case, if the essay question is asking about ABH and GBH, you would define what those are and explain the issue at hand that the essay question is asking you, followed by a thesis statement. In the body paragraphs, that's where the details come. In the introduction, usually you only put the definitions and explain what is the essay question is asking, the relevant laws. However, you never put arguments in the introduction. For body paragraphs is where you put the arguments and you need to argue for and against the statement in essay questions. In the conclusion, you need to sum up your main arguments and answer the question asked. So in this case, the question was defense of consent should not apply to ABH and GBH. In the conclusion, you would need to answer whether or not defense of consent should apply. After presenting all your arguments, you need to side with one side of the argument, whether you are for applying defense of consent to ABH or GBH, or you are against, and you need to reason your position. In the introduction, you could start by defining what is actual bodily harm. Actual bodily harm is assault occasioning actual bodily harm, which is defined under Section 47 of the Offences Against the Persons Act 1861. Actus reus of ABH is an assault of battery that causes ABH, actual bodily harm. So the base offense here is assault or battery. Assault is defined under Section 39 of the Criminal Justice Act 1988. For assault to be committed, defendant shall cause victim to apprehend immediate unlawful personal violence. Assault does not require any physical contact with the victim, and that was established in the case of R.V. Ireland. If you're writing a coursework, you should put all the cases in footnotes. If you're answering an exam under tough time conditions, so if you have only limited time to answer a question, then I believe that just putting the case name in brackets would be enough. Mens rea of assault is intention or recklessness to cause victim to apprehend immediate unlawful violence. Mens rea of Section 47 is the same as mens rea of assault or battery. There is no need to prove an additional element, mental element, for Section 47. Introduction continued. Battery is the infliction of unlawful force by one person upon another. So the difference between assault and battery is that for assault, it's only making the victim believe that unlawful violence will be inflicted upon him. The actions that may constitute to assault can be shouting at someone. When defendant aggressively shouts at someone, that can cause the victim to believe that the defendant would hit him. That would be unlawful personal violence. So defendant would believe that unlawful personal violence would be inflicted upon him. So if it's only fear by victim and no physical contact has happened between the defendant and the victim, that would be assault. If there is physical contact, that would be battery, unless a bodily harm has been inflicted. In that case, it would be either actual bodily harm or serious bodily harm under Section 20 or Section 18 of the Offences Against the Persons Act. Mens rea of battery is intention or recklessness as to causing the infliction of unlawful force by one person upon another. GBH, grievous bodily harm, is malicious wounding or inflicting GBH. In simple words, this means serious wounding or inflicting serious bodily harm. Because this statute is from 19th century, the language, the vocabulary it uses is a bit outdated. Grievous bodily harm means serious bodily harm. Mens rea of Section 20. Intention or recklessness as to causing some harm, whereas mens rea of Section 18 GBH is intention to cause serious harm. Therefore, we have two offenses of grievous bodily harm, the one under Section 20 and the one under Section 18. The only difference is the mens rea. The mens rea of Section 20 is the same as is intention or recklessness as to causing some harm, whereas mens rea of Section 18 is intention to cause serious harm. That is why there is a big difference in maximum life imprisonment for these two offenses. For Section 20, the imprisonment maximum sentence could be 5 years, whereas for Section 18, maximum sentence could be life imprisonment. The thesis statement for this question could be similar to this. The present AC shall critically analyze if the defense of consent should apply to ABH and GBH. To sum up, in the introduction, we have defined what is ABH, what is GBH, and what are the requirements for ABH and GBH to be committed. In what kind of circumstances a defendant would be convicted of ABH or GBH? What is the actus reus? What is the mens rea? Citing relevant statutory provisions and relevant cases. In the body paragraphs, you need to remember that first you need to explain the law and followed by the analysis, rule analysis, but divide into small chunks. Don't try to put explanation of many cases and principles in the same paragraph and then try to analyze everything all together. I suggest that you divide it into small parts, as small as possible. So you could start by defining what is defense of consent and how does it work? Where does it apply? Defense of consent applies normally to assault and battery. For example, in everyday situations where without intending to touch each other, for example, in a crowded public transport, you may accidentally push someone because there are too many people and you have to get in and you may push someone. If there was no defense of consent implied in that kind of circumstances, that could be battery. However, we have defense of consent implied in that kind of everyday interactions. So the people are not convicted of battery and assault in that kind of, people are not convicted of battery in that kind of circumstances where it's a normal, accepted interaction between people every day, such as getting into a crowded public transport, for example. However, the court is reluctant to accept defense of consent for more serious offenses like Section 47, Section 20, and Section 18. So you would start by explaining that defense of consent applies to assault and battery. However, as a general rule, it does not apply to Section 47, Section 20, and Section 18. because those are more serious offenses, and the court is reluctant to accept defense of consent for serious bodily harm. However, there are exceptional categories. For example, body modification, tattoo, and piercing. Those are recognized exceptions, and defense of consent applies. So if someone gets a tattoo, the person who does the tattoo will not be convicted of Section 47 or Section 20 because it's an exceptional category and it's recognized as the defense of consent applies. Sport, we have a lot of violent sports, for example, boxing, and sport is also another recognized category where defense of consent applies. Horseplay, religious reasons such as circumcision, again, a recognized category. And of course, surgery. Surgery, when doctors perform a surgery on someone, the doctor usually makes the patient sign a consent form, and that consent will be valid because surgeries are one of the categories where it is exceptional category recognized by English law that defense of consent applies, even though Section 47, Section 20, and Section 18 offenses apply. In an essay question where you're required to provide critical analysis, I suggest that you critically analyze, you provide arguments whether or not these recognized categories are justified in today's society. The controversy comes in with cases such as R.V. Brown, R.V. Wilson, and there are a lot of academic commentary in this area of law arguing that we need a reform, or we need to at least extend exceptional categories that I just listed. In R.V. Brown, defense of consent did not apply because the court said that sadomasochistic activities are not a good reason where defense of consent should apply. So the defendants here were homosexual men that were involved in sadomasochistic activities, and the court argued that inflicting injuries in this kind of sexual activities was not a good reason to inflict GBH, whereas all the exceptional categories, according to the court, is a good reason to inflict GBH. I can agree with, I can definitely agree with surgery. It is a good reason to inflict GBH. However, things like religious reasons or sports and tattoo and piercing, that's arguable if it's a good reason to inflict GBH. And obviously, there are a lot of academic criticism as to what is a good reason and what is a bad reason for inflicting GBH. The court in R.V. Brown was criticized for enforcing social norms and values instead of the law and human rights, because in R.V. Wilson, which was a very similar case, defendants were husband and wife, and they were involved in sadomasochistic activities. But the court said that the defense of consent applied and defendant was not guilty of Section 47 because they were a married couple and the court did not need to be involved in private lives of married couple. So the controversy here is that in the first case, there were heterosexual men who were involved in sadomasochistic activities, whereas in the case of R.V. Wilson, there were married couples. So what is the legal basis of distinguishing these two cases? Should in the modern times where everyone is equal, we have human rights, we have Article 14 of the European Convention of Human Rights that states that nobody should be discriminated because of their sexual orientation, gender, etc. Should this kind of differentiation exist? So that's the controversy here that you need to argue for and against. Critical arguments. I suggest that you apply Article 8 and Article 14 of the European Convention of Human Rights. you could argue if R. Brown is incompatible with Article 8. I believe there are cases that Strasbourg court have discussed about this area of law, and you could have a look at the Strasbourg law jurisdiction to find cases and what Strasbourg court said about sadomasochistic activities. There is a lot of academic commentary in this area of law, and for higher grades, I believe that you should have a look at peer-reviewed journal articles and make sure that your arguments here are very detailed and in line with the academic commentary from peer-reviewed journal articles. Also, you should try to be neutral, even if this topic is emotional for you, or you have your own opinions about whether or not this should be allowed. You should try to put your emotions aside, because in law, we always follow the law. Strictly, what is law, we follow it. And we need to argue for and against from a neutral perspective. So we should always try to be neutral and not allow our emotions affect our work. At the end, I suggest that every essay question, it's not about just criminal law, but every essay question, when you're required to critically analyze the law, there should be a reform proposal at the end. So first, you critically analyze the law, you provide arguments for and against, and then you propose a solution. How do you think the law should be improved? For example, in this case, you should argue whether English law on defense of consent to ABH and GBH should be reformed. It is a good practice to compare English law with other common law jurisdictions where the reform may have already passed. For example, in this case in New Zealand, the court already passed a reform. In the case of the court moved away from category-based decision-making for defense of consent because it did not respect individual autonomy and persons' right to determine the boundaries of their own bodily integrity. The court said that everyone has autonomy, everyone has a right to determine the boundaries of their bodily integrity, and there should not be just boundaries within which the court determines whether or not the defense of consent should apply. The case in Lee, this was New Zealand Court of Appeal, and the case name was Lee 2006, and I have a citation here. I will be sending you the slides after the session, so you have more detailed information. In this case, the New Zealand Court of Appeal adopted the minority position that was taken by Lord Mustill in the case of Brown, English law case of Brown. Presumption is that consent is available, defense of consent is available as a defense in respect of intentional or reckless infliction of ABH. Presumption can be displaced in case of certain dangerous categories of activity with a limited social utility. It was argued that court should consider whether to depart from the presumption by directly analyzing consideration of harm, victim vulnerability, and social utility on the facts of the individual case rather than in relation to the generic category of behavior it belonged to. In simple words, the court in New Zealand argued that we should not have this kind of established categories like we do in English law, surgery, body modification, sports, etc. Because in modern society, there may be more categories where infliction of harm can be accepted. So the court is keeping an open mind to this and taking the position that was expressed by Lord Mustill and Brown and saying that we should analyze each case on case-by-case basis. Circumstances of each case is unique, and we should accept the presumption that defense of consent can apply to ABH. This presumption can only be displaced if we see on the individual case that after considering harm, victim vulnerability, and social utility, defense of consent should not apply. So basically, the court is saying that there should not be like this kind of established categories and strict approach as to where defense of consent applies, but we should analyze each case, so the facts of each case separately, and by considering the victim vulnerability, social utility, etc., we should decide whether or not there is a good reason for the defense of consent to apply. In the conclusion, you should sum up your main arguments, but very important is that in the conclusion, you do not present any new points. All the points that you had to say, all the arguments you had to say should be above, should be before the conclusion. And finally, you need to answer the question asked. By this point, you should have already presented both arguments for and against the essay question. And in the conclusion, you need to side with one of the arguments, one of the sides of the argument. Either you agree or you disagree that ABH and GBH defense of consent should apply to ABH or GBH. And obviously, you need to reason your position. Why do you think that defense of consent should apply, and why do you think that defense of consent should not apply to ABH and GBH? The reasons can be things like, in modern society, it is hard to justify why the exceptional categories such as sports is a good reason to inflict GBH, but sexual activities is not. One could argue that boxing is also not a good reason to inflict GBH, but for some reason the court considers that sport is a good reason. So could it be argued that the court is following the social norms and values and social stigma to sexual activities? Should this be the case in modern society, where we have human rights and where we have freedoms? Those are the controversial issues that you should be addressing. But obviously, all your arguments should be reasoned according to case law, according to journal articles, and you should not be putting your emotions and your opinions there without justification. Always talk from third person, like it can be argued, it can be stated, instead of saying, I believe, I argue, because for you to talk from the first person, you should be a distinguished academic. And since you are all law students here, you should be talking from the third person. For more information, please visit our materials in criminal law. As you already know, we can help you with our study materials. We have notes, example essays, tutorial videos, quizzes, flashcards, where you can see simple study materials made by top students and the top law graduates who achieved 2, 1, and first-class degrees in different universities of England, like LSE, City University, BPP, etc. And our ready-to-go materials will help you to achieve first class. If you haven't done so, I suggest you subscribe. Also, we offer tutoring sessions tailored to every student's need to help students learn correctly how to get high grades, practice legal writing, and get some guidelines as to how to prepare for your exam and how to answer your courseworks. We can help you with your courseworks, with teaching you how to do relevant legal research, how to make notes of the applicable law, how to do the ARC structure, and clearly to get a first class, the art of argument making, which is very, very hard, and it requires a lot of practice. And finally, we can help you to prepare for your exam. We have already helped thousands of law students get high grades. Currently, we have 17,000 law students from all over the UK subscribed to our platform, as well as overseas. If you want to get a first class, please join SimpleStudying now. Thank you very much.